Hey folks, Attorney Andrew Branca here for the Law of Self-Defense. Well, the Apple River verdicts are in. Defendant Nicolae Miu was not acquitted on the grounds of self-defense. He was found guilty for every use of force against every individual that day on the river, on the Apple River in Wisconsin, but not of the most serious charges, not on the intentional charges. He was found guilty of the recklessness charges. These are the last minute added lesser included charges requested by the prosecution after the parties had closed their argument to the jury, but before the jury received their final jury instructions. And it was on these reckless charges, these last minute added, arguably ambush jury instructions for the defense, that the defendant was found guilty. So there was a little confusion about that when I was live streaming the reading of the verdicts. It moves quite quickly, so I wanted to clarify all that here. I'll step through each of the guilty charges and their degree of offense and their sentences, and then I'll play for you the live reading of the guilty verdicts from the courtroom in this brief show today, the sole purpose of which is to clarify those guilty verdicts. So let me pull this up here. Count one. Count one was the stabbing death of Isaac Shuman. He'd been charged, the defendant, Nicolae Miu, had been charged with first-degree intentional homicide. He was not convicted, not found guilty of that charge, but he was found guilty of first-degree reckless homicide. First-degree intentional homicide would have been a mandatory minimum life sentence. First-degree reckless homicide is a Class B felony, good for up to 60 years, plus 5 years deadly weapon enhancement. I would expect this judge, given his commentary during the jury instruction conference, to sentence Nicolae Miu to the maximum on every one of these charges. In fact, maybe worse than the maximum. I'll explain that in a minute. So here we're looking at up to 60 years, and I expect he'll get to 60 years plus 5 for the weapons enhancement for the death of Isaac Shuman. Then we have counts 2, 3, 4, and 5. This is the non-fatal stabbing of Dante Carlson, Tony Carlson, A.J. Martin, and Riley Madison. He'd been charged with first-degree intentional endangerment. He was convicted of first-degree reckless endangerment, Class F felony. Each of these is good for up to 12.5 years, plus 5 years weapons enhancement. And again, I expect he'll get the maximum. And finally, Madison Cohen, the purported battery of Madison Cohen. This is a Class A misdemeanor, up to 9 months, plus 6 months for the weapons enhancement. Now, having said all that, typically sentences are served concurrently in parallel to each other. And if that's the case here, the only one that really matters is the first one, the 60 years one, plus 5 years for the weapon enhancement, 65 years in prison. I expect the judge to sentence him to all of that. So for 54-year-old Nicolae Miu, that's obviously a life sentence and more. It could be even worse for him, though, because it's possible the judge here is permitted under Wisconsin law to order that these sentences be served consecutively, not concurrently, meaning they stack one on top of each other. And if that's what's done here, then we would add up all of them and we would arrive at a sentence of 136 years and 4 months and 3 months. So again, as a practical matter, it hardly matters. Nicolae Miu will be going to prison for the rest of his life based on these convictions. Prospects for appeal seem to me slim or non-existent. Prospects for effective appeal that achieve some meaningful relief, very minimal. There we are. That's where we are. So now I will play for you the actual reading of the verdicts from the courtroom today. Enjoy, or not. Hey, folks, one more thought I wanted to add, actually, before I jump into the reading of the verdicts in court. And that is that given that this defendant, Nicolae Miu, had been charged with intentional homicide and intentional endangerment, but not convicted on those, convicted on the recklessness versions of those crimes. So recklessness, not intentional. And given that he'd raised the legal defense of self-defense, but not acquitted on the grounds of self-defense, instead convicted of reckless killing and endangerment, it strikes me that what might have happened here is precisely what I thought the state was going for when it did this late edition ambush of these recklessness charges after the parties did their closing arguments, but before the jury was formally instructed during the jury conference where the jury instructions were finalized. And that is hoping for a compromise verdict. So it's quite possible that these jurors decided, listen, we saw this guy attacked. We saw the hyenas. We saw the circumstances. We can't hold him 100% accountable. And these young people, 0% accountable for what happened there. They played a role. So we're not going to convict them of intentional homicide and intentional endangerment. On the other hand, we have a dead 17-year-old. We have 4 other young people stabbed, some gruesomely. We can't just let them walk out of here with nothing, that this is okay. We think this didn't have to happen. So we're not going to acquit him on self-defense. Instead, we're going to compromise, not convict him of intentional crimes, not acquit him on self-defense, but compromise in the middle on the recklessness criminal charges. Now, of course, we won't know that unless the jury tells us. The jury speaks to the media. Even if they do, they may not be willing to concede that it was a compromise verdict. Compromise verdicts are not really something that's supposed to happen, but jurors are human beings, and these are the kind of compromises that human beings sometimes make. All right, with that final thought out of the way, now we jump into the reading of the verdicts in the courtroom. Enjoy, or not, as the case may be.
He's now to the left, on the other side of Aaron Nelson, left side of his defense attorney. The jury is coming in. A verdict has been reached. We should hear Nicolae Miu's fate in mere moments.
All right, please be seated. All right, we are back in session on the record in State of Wisconsin versus Nicolae Miu. The attorneys are present with Mr. Miu. 12 jurors are in the courtroom. Mr. Ashland, I understand you are the foreperson.
Correct.
Did your jury reach a verdict?
Yeah.
Did you reach a verdict on each of the 6 counts?
Yes, we did.
Okay, please hand the verdict forms to the bailiff. Verdicts read as follows. As to count 1 of the information, Isaac Shuman, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted. Question, did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes.
That's all.
As to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 3 of the information, Dante Carlson, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 4 of the information, Anthony Carlson, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 5 of the information, Riley Madison, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu guilty of battery as charged. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes.
What?
Members of the jury, I do have to verify that this is in fact a unanimous
That,
verdict.
that last one's insane.
So I'm going to ask each of you if I correctly read the verdict and if you agree with it. So when I call your name, if you agree with the verdict that I read, please answer by saying yes. If you disagree with the verdict, you can answer by saying no. Ms. Navarro, do you agree with the verdict that I read?
Oh, we gave her name out.
Mr. Cook, do you agree with the verdict that I read?
Yes.
Mr. Snell, do you agree with the verdict that I read?
Yes.
Ms. Belzil, do you agree with the verdict that I read?
Yes.
Mr. Wiley, do you agree with the verdict that I read?
Yes.
Ms. Knapp, do you agree with the verdict that I read?
Yes.
Mr. Diedrich, do you agree with the verdict that I read?
Yes.
Ms. McMahon, do you agree with the verdict that I read?
Yes.
Mr. Henderlong, do you agree with the verdict that I read?
Yes.
Mr. Ashland, do you agree with the verdict that I read?
Yes.
Ms. McMullen, do you agree with the verdict that I read?
Yes.
Ms. Lewandowski, do you agree with the verdict that I read?
Yes.
Any additional polling? No? All right. It is a unanimous verdict. Members of the jury, your service in this case is completed. You are free to read accounts about this trial. You are free to talk about this case with anyone. However, you
Guilty.
do not have to
Guilty
discuss
everywhere.
this case with anybody or answer any questions about this case other than from the court. So this includes the parties, the lawyers, the media, or anybody else. If you do decide to discuss this case with anyone, please treat any such discussion with a degree of solemnity, such that whatever you would say, you'd be willing to say in front of your fellow jurors or here in open court. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or the public. For that reason, please respect the privacy of the views of your fellow jurors. If you do decide to speak, please only speak for yourselves and not for anybody else. On behalf of my colleagues, Judges Needham, Vlack, and Nordstrand, along with my courtroom staff, thank you for your participation in this important case. Court is now adjourned. Please take the jury out.
All rise for the jury.
There we go. Juries are dangerous and unpredictable creatures, folks.